little love. It's a mother and daughter, and they show up to all the things, and they're lovely. They're lovely.
She has like a passion for justice.
We're faced with style, sharp minds, no delay. Uncovering corruption, paving the way. Reading the fine print, flipping the page. This is our stage. Yeah, this is our stage.
LawGirls Not Attorney has been, I think, at just about every hearing.
It's clear. With a voice they didn't want to hear.
LawGirls Not Attorneys.
Statutes to cases,
Then Amanda
we're
is there,
cracking
and
the code.
we have to get them on and chat with them. It's mom and daughter. She's a paralegal and a PI.
LawGirls on a mission, no fear inside. Facts in our hands, we ignite the
You can't come back. We decided. The Law Girls decided.
Next, we're going to bring up here LawGirls Not Attorneys. They're big supporters of mine. They've come to all of my court dates. And the Kelsey fits them. They always the Kelsey fits them and stuff too. Mother and daughter do.
of power, we make our stand. No shadows too dark, no line too grand. Mother and daughter, we're breaking the chain for the silence voices. We'll bear the strain.
Been one of the front lines people advocating for Kelsey. LawGirls, both of them, I should say, are a great tandem, those two. So great.
That's a mother-daughter duo that
It is.
that really kicks butt.
Yeah.
Uh-oh.
I'm not crying, you're crying. I'm not crying, you're crying.
Morning, friends. Happy Thursday, July 2nd, the year 2026. How are you? Are you doing well? How did you sleep last night? How did you sleep last night, little law girl?
Good.
Good? Very good. We're glad to have you back this morning. You glad to be back? Little law girl?
Yeah, did you do one of these yesterday?
Do you want to what? A show?
Yeah.
I did, in fact. It was later than normal. It was at like 9:45 because I took you to your destination. Not your final destination. Do you like those movies or not? Final Destination, yeah or no?
The first one, I was like,
Yeah. I don't know. I'll be driving down the road and I'll see like some stuff that looks like it would be some Final Destination stuff, and no.
Driving behind a truck with like the logs on it. No.
Correct. Yes, correct. Driving behind like a big rig with the long logs. Yeah. Creepy. Good morning. Good morning, friends. Good morning, friends. Whenever I say good morning, I bring myself back to when my littles were in school, and I always remember the cute little songs that their kindergarten teachers or whatever would sing, and it puts me in a good mood, and sometimes I still sing them. Is that dumb? I wonder if other people do that. Is it just me, bro? I don't know. They always have such cute songs in kindergarten and first grade, and I don't know. Adorable.
I had my multiplication table songs when I was in like second grade. That was my favorite.
Multiplication?
Yeah,
Hmm.
I still remember some of them.
Yeah.
Most of them, actually.
That's a good thing to remember. Oh, we talked about the other day. You were here for that when we were talking about how to remember the months. Like 30 days has September. April, June, and November. And one of our viewers messaged or put a comment in. Let's read it here, shall we? Shall we? Do you ever go read the comments, little law girl?
Nope.
No, that's okay. I do it. It's not really in your job description.
That's
Let
above
us
my pay
see.
grade.
It is above your pay grade, which is 0. We had somebody who came in. They were on the replay crew, and they said, for months, make a fist start with pointy finger knuckle, and that's January. Go down between the knuckles. Next for February, up March, down April, up May, down June, up July, then back to knuckle 1 for August, down September, up October, down November, up December. All months on the top of the knuckles have 31 days. That's how I learned. Can you imagine that one of our viewers, their handle is jas.rn38. I'm wondering if they're an RN, like a nurse. I betcha. That they...
What would have made you think that?
I know, right? They took the time out of their day, out of their busy day, to write that all out. How nice was that? I love it when people make comments too, like leave comments after the show. Love it, love it. And it helps with the algorithm. It's like, oh, people care about these people even after the show is done. They come back and watch and engage. That is really cool. It's really important. All these little things. You learn how to talk to the computers with like algorithm and all that stuff. It's pretty neat. I have even asked it, like yesterday, for instance, as I was clipping. So I asked it, where did it go? Where did you go? Where did you go? Oh, so in YouTube, you have this little like analyze thing where you can, it says ask, and it's AI that's in. You can go into like different people's videos and be like, oh, when did this person say that? Or when did, like I used it for Aidan, when did he talk about Gretchen Voss in this episode, right? And it'll take you right to the timestamp. It's the coolest thing. But I asked it, tell me, so I used it to clip afterwards. So this was to clip shorts because YouTube now likes shorts and it's pumping those out into the algorithm to, I guess, attract people. People will watch the shorts and then they'll come watch your long form, right? So I used it and said, like, tell me which the best clips are, which the best shorts are. And it gave me the timestamps with what it thought would be high impact segments, right? And so it made the most sense to ask YouTube because that's where I'm looking to do business, right? I'm looking to pull the shorts or make the shorts from my content. So I ask it to give me what clips out of my episode would be the most to be engaged in. And then I took it as,
hitting the desk.
oh yeah,
Desk
sorry.
with the camera.
Oh yeah, and it's like an earthquake. Oh. Yeah, that'd be scary. That'd be scary. Don't make fun of people. Don't make fun of people.
I'm not. I'm pointing out a fact.
Okay. Oh, because her desk does that, right? Okay. Well, thanks for alerting me to it, so I stopped doing it. I appreciate it.
You're welcome, because it's bothering me.
Oh, okay. Well, if it's bothering you, then it's probably bothering other people too. So thank you. You never know what's going to bother people, viewers. Some people hate the sound of like lip smacking. Sometimes I do that. But what are you going to do? You can't please everybody, right?
I've heard that Jim Altman does that.
Oh, yeah? So I went back and I said, tell me phrases or terms that are SEO optimal for each of those clips. SEO is what? Do you know, little law girl?
Search engine optimization.
Search engine optimization. I can't really break that down for you to explain it much more, but it's like words. It's words that...
Oh, great description.
It's great description. Are you mocking me, little law girl?
Yes.
So, for instance, we pulled one clip where from, not yesterday, the day before, where we talked about the Sean Ellis interview on Defense Diaries, and it gave me a clip about that where we were watching it. So the phrases that it gave me back were, and it's like hashtag, right? So it gave me hashtag jury duty, hashtag justice system, hashtag Sean Ellis, hashtag legal reform. Pretty neat. So if you know how to use it, you know, it can be very, very helpful. So, thank you of traffic for unpaid search.
No,
Oh.
nope, it's split up into two columns.
Oh, search engine optimization is the practice of improving the visibility and overall performance of websites and web pages in search engine results pages. It focuses on increasing the quality and the quantity and quality of traffic for unpaid search results rather than paid advertising. Very interesting. How do you...
It's supposed to make it more visible even when you don't pay for advertising.
Thank you. Makes you more visible even when you don't pay for advertising. Perfect. That's a great description. Thanks for breaking it down. I see a kitty boy. I see one of them wandering around. I know my cats by their tails because I have 3 black cats, and one of them, the middle guy, the floof, who we have seen recently on screen, his little tail, he has a shorter tail, and the very tip of it is all that really wags, just the tip of it when he's walking around. And sometimes he does a question mark with it, and it's adorable, and I love it.
He has the shortest tail.
He does have the shortest tail, that's right. And Fred has a long and skinny tail. And Binks, Thackeray Binks, I think that his tail is the most animated, if that makes sense. I don't know. So that was that. So now, to blow your minds, let's see. Hang on. What do I want to look at first? Do we want to look at the hearing yesterday?
The quote-unquote hearing.
The quote-unquote hearing. Not the hearing, not a hearing, because only the judge was heard. Or, yeah, let's look at that first, because I don't want to fall down a rabbit hole and not. Who should we watch it on? Let's see.
We were watching Bob and Allie a few minutes ago.
I know we were watching Bob and Allie, but did they watch it once through without stopping?
I don't know. We didn't get to watch the whole thing.
All right, well, let's try them out and see. Our friends Bob and Allie at Defense Diaries. What am I doing? That's what I'm doing.
Family hug.
Oh, family hug.
We appreciate you so very much. Spoogs says, I know Bob and Allie don't do the drama, but you have you two seen the clips of Jolene Lunzer's stuff? She's hilarious. I've seen some of it.
Wait, who's Jolene Lunzer?
She's a comedian
Allison.
who is taken upon herself to start a war with Jess Macchiato, I believe she calls her. Allison keeps asking me, she's like, who the fuck is Josh Mercado? I'm like, I don't know. This woman who claims
Allie,
she's
we'll
a-
talk. We'll talk.
Whatever, well talk about it later. Yes, I've seen.
I'll tell her, Bob. Stop.
For the
tell her.
record, civil action 2483 CB 069. For the record, civil action 2483 CB 0692. This is Paul O'Keefe, individually and as personal representative of the estate
Now-
of John Joseph O'Keefe
Wait,
III.
wait. Also, I am going to walk you through how I may or may not have been the very first on the entire internet. Oh, Trial Channel fixed the sound and all. How does it sound with Bob and Allie? Does it sound okay or not okay? We can go back and take a look at that. Let's do that. Let's take a look, shall we? Trial Channel. Karen Reed. Trial Channel. Oh, little Trial Channel, where are you? There you are. And okay, here we go. Wait. Oh, they have it on. They had the Zoom. I was going to go in and watch the Zoom, and then I was like, I called and they said that it was not open for the public, only the attorneys, and I stayed out of it. And then come to find out, I could have gone in because SJC was allowed to. SJC Media. Meh, that's okay.
This court now says,
They are the bestest.
Yes. Your Honor, for the record, civil action 2483 CV 0692. This is Paul O'Keefe, individually and as personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality.
That's what I wanted to tell you, little law girl. I'm going to tell you in real time. Well, I'm going to tell you how in real time I may or may not have been the first to identify what post on X. You don't even know any of this. Come closer. Come sit closer, my dear. Like, not on camera, but closer, okay? So I'll tell you as it goes down, okay? All right.
LLC doing business as CF McCarthy's et al. Your Honor, with your permission, at this time, I will call the names of the attorneys in attendance and ask that they state that they are present for the purposes of the record.
Thank you.
Attorney Brillahante.
Present, Your Honor.
Attorney Horwitz.
Present.
Attorney Fell.
Present.
Attorney Buck.
Present.
Attorney Diller.
Present.
Attorney Beaton has been excused, Your Honor. Attorney Holstag.
Present.
Attorney Rose.
Present, Your Honor.
Attorney St. George.
Present, Your Honor.
Attorney Donovan.
Present, Your Honor.
Attorney Dealey.
Present, Your Honor.
Attorney McCaffrey.
Present, Your Honor.
Attorney Hassett.
Present, Your Honor.
Attorney Maravellis.
Present, Your Honor.
Attorney Shipley has been excused. Attorney Tang.
Present, Your Honor.
Attorney Bell.
Present.
Your Honor, Attorneys Little and Mason are appearing by Zoom.
Yes, Your Honor. Present.
Attorney Jackson's getting some free publicity as well. For
Attorney Jackson.
And
Present.
people were like, oh, look at Evan, look over. That's funny, Mr. Woke in the corner. People were, when the judge said that, getting some free advertising, people were, and myself were like, rah, 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 rah. That was inappropriate that he made that comment. But really, now we see why. Because you could see on the screen, Worksman, Jackson, and Quinn, LLP, right? So it was, in fact, yes. Kitty says this all could have been done by Zoom. Correctamundo. For sure. But it told us a lot of stuff. I think it's going to be, yeah. Wait till we're going to wait and let little law girl see it because she has not seen it yet. She was gone the whole day yesterday.
Attorney Seligson.
Present.
And Attorney Rosenberg.
Present, Your Honor. You can sit down. Thank you. So thank you, counsel, for being here. I scheduled today to be in person because of the significance of what I was advised of last Friday, and because I find the quiet solemnity of the courtroom is a good reminder of the dignity by which courts are supposed to function. One commenter describes how every high-profile case now unfolds in two arenas, one governed by procedure and precedent, and the other by pixels, edits, and algorithms.
And I feel as if this judge is trying to force it to be in the courtroom. Like, we're not playing this out on, social media in the public eye. That's what I feel like yesterday was about. Like, make you come physically into court, because of what happened.
The courtroom has become content, and the law has become a spectacle.
Realistically, we're supposed to be able to watch this. We're supposed to be able to discuss it as the people. Like back in the day, way back in the day, people used to go to court to watch court. Like it was like watching the movies, going to the movies. It's where all the drama's at. Duh.
I recently held a hearing on a non-party motion for a protective order.
AKA
I required the moving party to provide certain information. Such material was filed together with a motion to impound. A hearing that included the motion to impound was held on Monday morning. I allowed the
So if you don't recall, or if you're not up to date on this, so this was in regards to Proctor and Michael Proctor trying to get out of his deposition, and he was suddenly away and could not attend the deposition. He had a medical need or whatever. He canceled like the Friday before he was supposed to have a Monday deposition. And then the judge had an emergency hearing and said to his attorney he was over Zoom, they were over Zoom, and he said, I need proof of this. I need proof of, where he's at, what's going on. His lawyer gave proof on Monday. That was not good enough for the judge. The judge gave until the end of the day, which at that point wasted an entire day for Alan Jackson, who had flown here from California, right? And so the judge ultimately ended up ordering Michael Proctor to be deposed that Monday afternoon at 4:15. However, at that point, Alan Jackson had flown back to California because he wasted a day. I think that they were going to do the deposition on Monday and Tuesday. And at that point, they wasted all of Monday. So he wanted to have 2 days back to back to do the deposition. Well, that was wasted at this point. So they ended up rescheduling it. And Proctor has so far done a couple of hours. I think it was like 2.5 hours. He arrived late, 2 hours late, and then sat for 2.5 hours before he ultimately had a panic attack, allegedly, reportedly, and needed to end the deposition early. That was on, I don't remember the date of that. I think it was June 5th. So June 5, 1, 2, 3, 4, 5. June 21st. June 21st. Thank you for correcting me. So June 21st. Right? Yeah. Okay.
Because it was recently, I think it was a Thursday.
Okay.
motion to impound during the hearing. The affidavits of the moving
Oh,
party.
right. But it was June 8th that they were in court, right? About the rescheduling it, or about rescheduling it, that Proctor couldn't show up, right?
Right.
Yeah.
and the attorneys were impounded. Following that morning hearing, I found that there was insufficient information to support a delay in the
Should just let the
deposition of the
judge tell it.
non-party from going forward. However, I further found that given the claims made in the filings, I would delay making a final decision on the motion until later that day to give the non-party's counsel the opportunity to supplement the record before me.
We all talked like us out here in the community, the people. We're all talking as we do. And the consensus was like, okay, read between the lines here. We've seen it in cases before, or with celebrities, we've seen it before, where they'll be gone for a period of time, and read between the lines. What does that mean? They're either in a mental health facility getting treatment for a mental health issue, or they're in rehab, right? So we were all like, that's probably what's going on, and they need to provide proof of it.
I scheduled the matter for further hearing that afternoon at 4:15 with the expectation that there would be additional filings. At 2:22 p.m. that day, the non-party's attorney emailed the clerk of this court and all counsel of record, excepting one, additional materials in support of the motion for a protective order.
Proctor's attorney.
The filing included a motion to impound additional materials. Exactly 30 minutes after the email to counsel of record of the additional material, which included sensitive and private medical information. Similar information to what was in the exhibits to the filing and marked provisionally impounded was posted to an X account at 2:52 p.m. Upon learning this information, I ordered that the parties and counsel provide certification to the court as to all facts known to them as to any dissemination to anyone.
So at this point, I stop and I go, oh man, who could this have been, right? So I head over to where I know he just said the information was disseminated, which was on X. And I looked to see who. I put in that date, that time, and I think it was Michael Proctor as a search phrase. What is it called? Not a search phrase, but I don't know. The word that I'm searching for, huh? Keyword, right. Yeah. Search word, keyword, whatever. So I put in the date, the time, Michael Proctor, and it gave me back results. I asked it, who posted about Michael Proctor at this time? What it came up with was a post by Aidan Kearney. I thought that as soon as I saw that, I was like, okay, the fix is in. I think I said, it was like, oh.
Parties and counsel in this matter of any of the contents of the material impounded on June 8th, 2026, and I scheduled this appearance for today.
Now we all know, going back to Aidan's show, that actually he's talking about, the judge here is talking about 6/8. On 6/6, Turtleboy in his regularly scheduled Tuesday night show, his Saturday night show, said that he had received a tip from someone that Michael Proctor was in a mental health facility. Do you remember that, little law girl?
Yep.
That was 2 days before this all happened. 2 days before Proctor's attorney submitted additional proof of why Proctor could not show up, right? So we will take a look at that real quick, because I think I have it pulled up. No, that's not the one, but that's okay. I can find it quickly enough. And it is that one, and we're going to pause you. And when does he speak about the tip he received? Okay. So I use this little doodad down here, this little ask star, and I typed in, when does he speak about the tip he received? And it says, Aidan Kearney discusses an unconfirmed tip he received regarding Michael Proctor starting at 1:54:44. So let's go to that.
This is a tip that we got in the inbox. And again, this is like one of those disclaimers. I don't know if this is true or not. So I'm just reporting this as a tip. That's not necessarily 1000% confirmed at all. That's 0% confirmed, but I'm just going to read it. Because when when a tip has like slightly more juice than like a completely made up shit, this one seems to have slightly more juice. All right. I got credible info from my coworker. He spoke to Proctor's wife, and he is in a psychiatric hospital in Florida for treatment. He was at McLean's in Belmont, but left for Florida, and now he's being treated down there. I know from past comments from my coworker, but just learned about the hospitalization a couple days ago. His wife and him are absolutely done. That's confirmed. She has separated herself from him for obvious reasons. So again, this is unconfirmed. And they go on to say, he's not sure how long this has been going on for with the ex-wife in the exact time, but it's been at least 2 months because of the previous comments from my coworker about him being separated from his wife and in Florida or around 2 months ago. The coworker's wife is one of the best friends with Elizabeth Proctor, so the info is pretty solid. This kid that tells us this stuff only gives us info once in a while. It's not everyday conversation, unfortunately. He does have sympathy for Proctor, which I do not.
So that is that day. Okay. And that is, go away. So that is 2 days before. That is on 6/6, 2 days before.
1 day before 6/7.
1 day before 6/7. That's accurate. And that is what the judge is talking about, right? And then if you come here, no, stop playing, stop playing. Stop playing. No, there we go. This I want to close down. And then let's bring yeah, we'll bring that one up. Too many tabs open. The story of my life. Well, let me pull it up so you guys can scroll along with me. What do you say? Okay. Okay, so this was me yesterday at the time when I used my Scooby-Doo clues. Maybe later, go away. And I said, this is absolute BS. The judge is going to point the finger directly at Dr. Turtleboy. Why does this feel like a setup? Outrageous. So I had come in and confirmed. So here's the post that we identified. So it says, Michael Proctor decided to have a mental health crisis after the whole world found out how racist he is. Sources tell us he checked himself into a mental health facility in Florida to try to avoid today's deposition. They filed a motion at the last minute on Friday to delay the depo, but the judge wanted proof. They submitted an affidavit that was impounded because it likely said Proctor was in a mental hospital. Now, listen to that, because that is very, he said they submitted an affidavit that was impounded because it likely said Proctor was in a mental hospital. He has no idea what it said. He is using his context clues along with the tip that he received 2 days before. I mean, it's pretty common sense, okay? Karen Reed's lawyer made the mistake of saying the scheduling of the deposition was strategic, which the judge took issue with based on her comments on the Today Show. He stayed the depo for 24 hours, and at 4:15, a hearing will be held. My guess is he's going to tell Proctor to jump on a plane and stop being such a this word, we're not going to say it, so Alan can depose him tomorrow. So this happens at 10:52 a.m., right? So there was all this speculation, like I had said, this is what they're talking about. And people were like, no, dumb, that's at 10:52. But it is the one. And we have people such as like the Matas and Corey Hopkins confirming. Because, this is what I used when I searched it in X to pull it. And I was like, are you sure? Are you really, really sure? Are you sure? Because I don't want to say this if it's not. Like, what do you mean? It says 10:52 here. How can you know it's 2:52? Was it the only one? Challenged it, pushing back, right? And so it said, yes, it's confirmed as 2:52 p.m., 14:52 GMT on 6/8/2026. Aidan Kearney posted it then. The full post discusses Proctor's alleged mental health crisis, checking into a Florida facility to avoid the deposition, the last-minute motion, and the impounded affidavit with private medical details. This aligns exactly with the impoundment of Proctor's medical private information that day in the civil case. Timestamps on X are typically in the user's local GMT adjusted time. 14:52 corresponds to 2:52 p.m. Eastern, the relevant zone for the Massachusetts case. No other matching post appears at 10:52. So I was still like, I was pretty sure, pretty sure. But, yeah, you want to be sure. And I said, we shouldn't have to be guessing about what he's referring to. Like, I feel like the judge should have been like, see, here's the X post, so that people could look at it and be like, oh, yeah, we're good. All of us in this community are really good at picking things out because of everything that we have witnessed play out in Karen's case, in Aidan's case, in other cases. It's one thing that we are really good at, right? So I don't know what that is. Show. Ali Mata says, thanks to our chat on Defense Diaries, YouTube today, the Michael Proctor leaked medical info debacle has been solved. The judge got bad intel with a UK timestamp and owes all the lawyers an apology. And that's fun. This was funny too.
What I want.
Somebody made this. Ready?
Hear ye. I do what I want when I want. Hear ye. I do what I want when I want.
I was laughing. Let's see. And then Corey Hopkins posts this further proof. Ready? So she says, this sure could be the tweet with the incorrect timestamp that the court saw. But the time issue is so easily verifiable. It could have been disproven in 2 seconds if the court just looked at the source. I'm dumbfounded that this could be the source of today's chaos. So let's make it bigger. Let's embiggen it. All right. So 252. What we're looking at is this. Ready? So we're looking at this, the time being changed in the middle of the screen there. Ready? You switch it to set automatically. Look, it changes to 1052. Let's watch it again. 252. Switch it. Set automatically to New York time. Come back. 1052. Would you look at that? No, I gotta go back. No. Where's the X button? No. Where are you? Right here? Okay, there we go. So, yeah. Was that all there was? Yeah, that's all there was. I love that thumbnail. And this is exactly what it was like. Like, it put Karen's head on backwards, though, which is really weird. Her head backwards on the Spider-Man. Oh, no, don't play. Oh, there we go. I love making these. These are, like, fun. Fun. So, let's go back to the judge. Are we there? Are we right there? Yeah, let's go back. Oh, no, share it, Mama Law Girl.
Nor are they aware of any facts regarding the dissemination of the contents of impounded material to any person or entity other than the parties in counsel in this matter. However, somehow, an ex-account holder, not part of this case, apparently received information that was at least provisionally impounded.
Not, in my opinion, from my perspective, what I think, for me, the clues that I'm putting together, maybe they're not right, maybe they are. This is a, how you say, coinky-dink, right? Because Aidan posted it 2 days before, right? Now, I wonder if this is part of the Remember campaign, little law girl.
What's the Remember campaign?
The Remember campaign, if you remember. Oh, did I not post that on? Yeah. Did I not post it on? Hold on. Let me see here. I thought I posted it on X yesterday, but I guess I did not. What in the world? One thing I can't stand about X is like how when you tag somebody in something, it like doesn't go to your page. It goes to their page. so it doesn't show up on your profile. It's very annoying. Mm-hmm. Let's see. I wonder if I put it together. Oh, I think I did. So many media things in so many places. My goodness. Nope, that's not what I wanted to do at all. Not one bit. My Atlanta. How very frustrating. You know what I'll do is I will send it to myself. Probably the easiest way to do things. Right? Well, little law girl, what else do you have going on that you can talk about? Ah, get out of there. Nothing? Nothing at all? Nope. Nothing? Tra-la-la? Oh, I did already put it there. Duh. I just have to go like this. Hang on. No, go like this. And like this. Ready? So, this was the Remember campaign. Ready? Oh, that's not me. That's not what I wanted. That's not what I wanted at all. That's the wrong one. Silly goose. That's what I played yesterday. What is wrong? Gotta have this stuff queued up ahead of time. Mama law girl. You know? Don't you think? Yeah. There it is. There it is. And you know how I know it's the right one? Because I gave it a heart. I gave it a heart. So it's listed as a favorite. What do you know about that? I need to be more organized with my clips and oh my Lanta. Like some things, I'm like, you probably already sent this to yourself a dozen times. It probably already exists. If I had done the right thing and given it a name before I sent it to myself, then guess what? It would be easily findable, easily identifiable. There we go. There we go. Alrighty. You're going to be like, all this for this little thing? That's all right.
Just remember.
All right. Here we go. Wait. Shush. There we go.
Just remember, I'm seeing a lot of questions in the chat. Just remember, as Pedro said, remember. Everything, 60% of everything I do is by design. Sometimes. Just remember that. We sent some messages back and forth, and we intentionally wanted to get out there just to prove that there was a hacker. Remember. Remember. I'm always 2 steps ahead. I'm always 2 steps ahead. Just remember that. Remember. Remember.
And if you remember, get out of there. Stop sharing. Stop sharing. Get out of there. If you remember, that was in regards to his Gretchen Voss interview. Now, you could be saying, he could be saying, listen, Scooby-Doo, calm your hemorrhoids. Or they could have to do with one another. I don't know. I don't know. Who, you might ask, who brought this information back to Judge Gildea? Who did that? Who was like, hey, judgy boy. No, that's disrespectful. Hey, Mr. Judge. No. Hey, Judge Gildea. That's probably better. Your Honor? Yeah, that's good. That's probably better.
Yeah, you think?
Yeah, I think. Yeah. So, wonder who that could have been. There's speculation. Now back to this.
Orders of the court have been violated either directly or at the very least in spirit.
Not by anybody here.
If these orders are to have any effect, all parties involved must operate with integrity.
Also, check this out, right? So when Aidan posted that on 6/6, it was not 6/7. When he posted that on 6/6, it was long before there was ever an order on 6/8, and he's not a party in this case. This is centralized. This is why it's so difficult that there's so many cases like interweaved and going on, and because this is only in the wrongful death case, which he is not a party in.
Rule 13C of the Uniform Rules of Impoundment Procedure imposes a duty on all persons to protect the confidentiality of impounded material. Additionally, Rule 3.6 of the Rules of Professional Conduct prohibits lawyers from making extrajudicial statements that they know or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding.
Now, keep in mind, I'm going to go look this up. Of course, rules of professional conduct, right? I have to make sure when I do that, that I do it in civil. This is a civil case. So it may be that if you go look this up in criminal 3.6, it's going to be a completely different rule. Okay. Oh, we have to talk about robot lawyers. Oh my God. I just about jumped out of my skin.
In cases like this, where all parties involved are aware of the public attention, I expect that everyone is taking every precaution to preserve confidential information, to follow the rules of the court, and to adhere to my orders. Because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. If necessary.
So what does that mean? I temporarily stayed testimony of the non-party. So he had stopped Proctor's testimony, right? Was not going to do any more deposition. Like, hold your horses, not proceeding. So who benefits in all this? Proctor, who does not have to keep testifying, right?
I am fully prepared to make such order permanent as permitted by Rules 26 and 30.
So he's prepared to make that permanent, that permanently Proctor doesn't have to testify. What is that?
To any issue counsel may raise as to the management of discovery issues being within my discretion, I invite you to look at the following cases. In the 2003 case of Buster v. George W. Moore, Inc., 438 Mass 635, the SJC stated at page 653, in general, discovery matters are committed to the sound discretion of the trial judge. In a 2002 appeals court case, Mattoon versus the City of Pittsfield, 56 Mass App Court 124, the court stated at page 131, trial judges have broad discretion to make discovery and evidentiary rulings conducive to the conduct of a fair and orderly trial. In the 1987 case of Solomon A. versus B. Gruhl, 399 Mass 790, the SJC stated at page 799, the conduct and scope of discovery is within the sound discretion of the judge. In Cronin versus Strayer.
Oh my goodness.
In Cronin versus Strayer.
No, I want that citation.
Discovery is within the sound discretion of the judge. In Cronin versus Strayer.
No, I want that one.
Case of Solomon A. versus B. Gruhl.
87.
399 Mass 790. The SJC stated at page 799, the conduct and scope of discovery is within the sound discretion of the judge. In Cronin versus Strayer, 392 Mass 525, the 1984 case, the SJC stated at pages 535 to 536.
I'm sure they did.
We remind judges that the scope and timing of discovery is within their discretion, and the prevention of discovery abuse is sufficient justification for the authorization of protective orders. With this authority at hand, judges should not hesitate to exercise appropriate control over the discovery process. And finally, in the 1987 case of Campagna versus the Board of Directors of the Massachusetts Housing Finance Agency, 399 Mass 492, the SJC stated at page 503 that Rule 37 affords a judge broad discretion to impose whatever sanctions are just in order to ensure that the discovery process operates efficiently. The malicious publication of private information concerns me.
It concerns me that it would be positioned that way. The malicious publication of private information. Like, that's pretty bold statement to make, accusation to make, when we don't get to see the proof of that, when the lawyers don't get to see the proof of that. I hope that AJ or someone, I'm sure, filed, we'll have to check the docket today, filed something like requesting to see that, or I'm sure.
Opinion that one may have of a non-party, even if warranted, such an opinion does not allow for the disparate treatment of such individuals.
Even if you think Proctor's a douche.
All people deserve fair and equal treatment in our system of justice, regardless of any personal characteristic,
I got that pulled
as
up.
abhorrent as some of them may be. What I am looking for is for the parties is adequate assurances that their discovery served justice and not any desire to weaponize the rule for pettiness and profit. If the parties and lawyers would enter into an agreement,
listen to that.
Parties is adequate assurances that their discovery served justice and not any desire to weaponize the rule for pettiness and profit.
Pettiness and profit.
If the parties and lawyers would enter into an agreement to hold private, personal information in confidence, and if the terms were acceptable to me, I would consider entering it as an order of the court so that any violation would be grounds for a contempt finding and appropriate sanction, including dismissal or default.
Dismissal or default.
Such an order would need to be more than a stipulation that deposition testimony can only be used for the purposes of this case. I encourage the attorneys to confer and to seek to reach an agreement. In the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking. My final request to counsel with an appearance in this matter is to familiarize yourself with Rule 3.6 of the Rules of Professional Conduct relative to publicity. The rule sets forth a basic general prohibition against a lawyer's making statements that the lawyer knows or should know will have a substantial likelihood on materially prejudicing an adjudicative proceeding. The rule applies
To put this all on these attorneys, that's
to lawyers who are or have been involved in the investigation or litigation of a case and their associates. As the comment to the rule notes, it is difficult to strike a balance between protecting the right to a fair trial and safeguarding the right of free expression. However, preserving the right to a fair trial for everyone necessarily entails some curtailment of information that may be disseminated prior to trial, especially where trial by jury is involved.
who thinks.
Rhonda, will you-
Oh, no, go back. What are you doing? No. We'll find it. We'll get to the point. Who here thinks that any of these lawyers involved would take the risk of disseminating Proctor's private health information? Unless, of course, I had seen speculation that if it were that maybe it came from inside, like the calls coming from inside the house type of thing, a new phrase that I learned from our new favorite Judge Jolene. Who knows? To create, I don't know. There's so many possibilities.
Case through social media. Be what a trial lawyer should be, one that tries their case in the courtroom.
Oh, we were past
And remember the provisions of
right?
Massachusetts, which provides in part, I solemnly swear that I will do no falsehood. I will delay no man for lucre or malice, but
I like to think here, like when you're pointing the finger, how many do you have pointing back at you, right? Like, judges are human too.
I will delay no man for lucre or malice, but I will
Now,
conduct myself in the
I don't think there was monetary gain, obviously, or malice about, I don't think that was, I think it was a mistake, an egg on your face kind of thing is what it's going to come down to. But jumping to a conclusion and not having, like, why, if you don't want to pander to the media, if you don't want to give us a show, if you don't want to give us content, why not do this over a Zoom? If you insist on doing it in person, why not do it in camera? Right? Could he not, like, do it in camera with just the attorneys? Like, yeah, we don't get to see it, but oh well, like, it's a serious thing that needs to be addressed seriously. You know what I mean? So,
the office of an attorney within the courts, according to the best of my knowledge and discretion, and with all good fidelity, as well to the courts as my clients. So help me God. I wish all of you a happy 4th of July on the anniversary of our America's 250-year-old democracy. May it continue to succeed with all of us working to maintain the rule of law. Thank you.
For the record, this matter is continued to July 10th, 2026 at
you
2
can see
p.m. for
AJ's
hearing on
face.
motions
He's
to
like,
compel.
what? He, like, look. Oh, take it back 1 second. He's like, looks thoroughly confused. Like, what just happened? What just happened? Can we go in on this? No, we can't zoom in. Can we zoom in over here? No, that's okay. But you look at Rosenberg is like, come on, really? Alan Jackson is like, huh? You can see Seligson over here, and he's about to speak.
Motions to compel the criminal fourth session.
Court stands in recess.
There's no opportunity to be heard? There obviously no opportunity to be heard.
I was unaware. I'm just covering for Clark Donovan today.
Is there an opportunity before everybody departs to let the judge know that we would like to be heard?
I absolutely.
Thank you. That's it. That's it. One second. Yeah. Some language is incorrect, or which is incorrect. It has to be correct. And to correct that record. And if you ever else should have no.
He's not going to let us be heard.
Well, we'll use that as another.
Interesting, right? We're going to close that. Oh, no, sorry, Peter. No. Stop. Go away. Go away. We love your face, but no. Now, let's take a look at I think it's on X. Grant was nice enough to get video on the way out. Let's see. Here it is. Hang on, I gotta pause it and then begin and go like this and then bring it over, and we will make sure, please, little law girl, that you share the link for this in the chat, okay?
I think now would not be a good time for a comment, so I'm going to reserve all comment. Is that good?
What about the fact that you weren't allowed to make any case in front of the judge? What were you hoping to say?
So I'm going to reserve comment. Nice try, but I don't think we have any choice. Nice to see you guys.
Have a good 4th of July, Alan.
I can finally see what Boston looks like without snow. I didn't know. No idea.
You were here on June 18th. Just saying. It's okay. I think he was totally shocked. Like, I do. We see Tom's CPU there. And there's that. So thank you. Did you make sure you put it in the chat, little law girl?
What in the chat? You never told me what I was supposed to put.
I did. Grant's thing. Grant's to his ex. You can put it there. I'll put it. I'll drop the link to his, because this is where I found it, his ex, okay?
Okay.
And then let's take a look at the chat. Also pinned in the chat is the Grifty, the Venmo and Cash App. So if you take a look, somebody said the other day, like, I said, what should we call it? Turtleboy's got Turtle Chat. Jolene has JoJo chat. Somebody said you should have girly chats. No, Grant did not leak the medical information either. No, he posted the order of the court. Once he got the court order, let's take a look and see if we can find that. Larry Foreman. No, I don't want YouTube. I wanted X, silly goose. Now, Larry Foreman said that he received an email similar to, let's see. Where is it? Here it is. Okay. Are you guys ready to have your minds blown? Not really, but it's just another piece of the puzzle. So this is Larry Foreman. He is the DUI guy, right? Lawyer on YouTube. I don't really watch him. I have. But so he says that he received this email. He says, I love and trust my fans. A lot of you emailed me with tips, suggestions, and compliments. This is an email I just got. I never heard from this person before, so that's already sus. Source, trust me, bro. Could be the McAlbert's camp, could be legit, you decide. And it says it's from Mike. He blacks this part out at Yahoo. To his email, larry@larryforemanlaw.com. It was at 11:46 yesterday, and it says AM. It says, hi, Larry, love your content. I have firsthand info that Proctor's estranged wife leaked his mental health into info well before the info was given to the court. She shared it with her friends that shared it with their husbands. One of those husbands is my coworker that shared it with me. That info eventually got to Turtleboy well before the court ever heard of Proctor's motion to delay any deposition. So, you guys decide what it means. What does it mean? What does it mean? I don't know. Who knows? Amber says, dude, KP sent Aidan fake info about Colin before through email. I bet this is her or someone within her island of misfits. Very well could be. Good morning. It is very strange. Scratch that. Well, remember, I don't know. I'm eager to see this all play out because this is not a mystery to some people, I'm sure. Some people know. Obviously, the sender would know, right? Very interesting. I wasn't involved in any of it, but it was me. If it was me, I would send all this information to the judge. I think if it was me, I would send it all to my lawyer. If the judge had a post at 2:52, show us, that's what I said. We need receipts. Are we supposed to blame people with one-sided? Yeah, supposed to blame people with one-sided accusations. I also speculated, I wonder if this was done to make, the motivation behind it was to make Karen mad at Aidan. Who would that benefit? right? I know that both of them are smarter than that. I was dead set on what I had thought, but the end of that email wasn't like the Turtleboy one, and now my ADHD brain has entered confusion. How is it different? I'm curious because that's exactly how my brain works too. I'm like, what is different? What is the same? What is inconsistent? It just, those types of things stand out to me, and it has proven pretty useful doing what I do, doing private investigation, right? This was done to remove cameras in the courtroom. I mean, I don't know, but it's possible. But when you give people, if you take the cameras out of the courtroom, what's that going to do? It's just going to make people want it, like they're going to call baloney for daytime television, baloney, BS, and it's going to make people push harder. And it does not do anything when you're trying to promote confidence in the court. This is not the way, homie, in my opinion. So I jotted down on my notepad that I wanted to go to Ian at 26 minutes. So we're going to do that and see what I was telling myself. Hang on. Pause. And then
my rules 26 and 30.
So what he's threatening here, what the judge is threatening is, I will prevent you from getting any discovery about Proctor permanently. And you know what I'd be seriously considering if I was Proctor right now is, hey, how do we engineer another leak? Because if the engineer, like if the, and this also basically suggests that he's blaming Karen Reed's team, right? Because who benefits if he bans further discovery of this is Karen Reed, not any of the other parties, Proctor and the House defendants, rather, or the people who benefit. It hurts Karen Reed. So, like, Judge, you're specifically threatening one side here, notwithstanding the fact that you don't know who released it. This is starting to feel like bias. He's assuming that this malfeasance came from one side when he doesn't have that information. He doesn't have those cards. And Judge, you can't assume that it was Karen Reed's side. That is improper. That is bullshit. Don't like that. Don't like that at all.
To any issue.
So I also dropped the link for Ian's YouTube channel, Runkle of the Bailey, into the chat as well. And yeah, please go give him a like on that video if you would be so kind, because we do like it. And he is a trusted in my, I trust him, so for him to say that, it means a lot to me. So let's take a quick peeky peek at this. Little Law Girl, is there a bus stop live set up? Yes, no, maybe? Okay. I'm going to take a quick look. Oh, let me check Cash Apps and Venmos really quick. And then we will take a look at that lawsuit that some in the chat were talking about. I have it pulled up where this judge is a litigant, and as is Brian Albert and many other, Judge Krupp, many other names.
No, nothing yet.
So folks are saying, like, is this a conflict of interest? So I don't know. We got a Cash App from, let's see, for your hard work and dedication from BJ. Thank you. Thank you so much. We appreciate that. Mm-hmm. Little Law Girl says, mm-hmm.
Money, 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 money. Money, 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 money.
You scared me for a second there. I was like, you played it without me. Play it one more time.
Money, 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 money. Money, 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 money.
And nothing in the Venmo. All right. So, people asking Just to Serve TV about it, and they didn't want to bet it, so I wasn't sure if it was real, but I trust Melanie before anyone if what was real. Hang on, I gotta go back and look. Are you talking about the lawsuit? All right, let's see. I read the filings in that civil case. That guy names everyone from George Soros to Tip O'Neill and the deep state. It's still an active and ongoing case, so I mean, regardless of what...
Is that all defendants?
Yeah, regardless of what anybody wants to say, what anybody thinks of the case, what anybody thinks of the merits of the case, it's still an open and ongoing case where these parties are litigants, right?
Well,
so let's take...
Did you keep the case number up?
Yeah.
Because I'm going to bring it up on mass courts as well.
Okay. Oh, it's going to stay there. Okay. So we have Nicholas Neskos, Esquire, and they represent the plaintiff, which is Raymond C. Green, Inc., as trustee of the Raymond C. Green Trust. Then we start with defendants.
One more thing. What is the county?
It is Suffolk, I think.
Superior?
Civil. Yeah, Superior. Yep. So we have Nicholas Fiorillo. We have Tracy Fiorillo. These are all defendants. Ocean Vacations Realty Trust. Got Capital LLC. Got Space Data Fund. Got Space Data Partners. Got Space Development. Ocean Development Partners. These are all business names. So Louis Del Pedio, Cynthia. It's all in. Is it all? No, it's not in alphabetical order. Thomas O'Neill, Stephen Lynch. I feel like I've heard that name before. William DeBella, Thomas Quinn, Brian Sheehan, George McLaughlin, Daniel McLaughlin, Nicholas Neskos. Wait, were they? That was an attorney too? Oh, a party attorney is listed as. Okay. These are all attorneys. My Atlanta.
You know who the plaintiff is, right?
But wait, Peter Krupp is listed as a party attorney.
Huh?
Oh, is it saying who the party attorney is over here? Okay, so defendant, right. So no, it's saying defendant. Then Mark Gildea. And then I'm looking for Brian Albert, which I did see when I looked at it yesterday. Oh, Carl Dougal.
They filed for bankruptcy in 2023.
Carl Dougal. Brian Albert. It doesn't have any more information. But I did pull up a couple of Events. Let's see. I'm going to take it off the screen just so I can scan through and not give you guys the dizzies. Okay.
You know who this Raymond Green is, right?
No.
Hard money lenders. It's mortgage lenders.
Okay. That's not, well, we're not going to say things on camera that we don't have confirmed. So I will, if we want to discuss, you want to do some deep diving, you can do that. Get a notepad and do it. But we're not going to say things on camera that we have not confirmed. That is the
I can confirm it. It's a website.
That's okay. Nope. Just, we're not going to discuss it on camera because we're going to.
Got it.
Oh, teenagers. We want to make sure that we're always giving you verified information. So it needs to be checked and site checked and second checked and third checked. So, okay. So this started in, oh, we need to close all these out. Can we do that? No, it doesn't look that way. Mylanta. Okay. So the last event they had was February of last year. They had a Rule 12 hearing. That was Judge Hornstein, Adam Hornstein, and it's in Boston. Yeah, so Suffolk. So that's where we were at before, Little Law Girl. That big, tall building in Boston. Oh, so there was a judgment in this. June 1st, 2026. Last month. Interesting. So let's go to, and again, this is civil court, so we get to look at the documents. So, okay, so afterwards, after that last date, the June 1st judgment, there were a couple more filings. There was endorsement on motion to dismiss all counterclaims against them for lack of service, which was allowed. Defendant Nicholas Fiorello's emergency motion for reconsideration of Judge Peter B. Krupp's orders, vacature of all tainted orders in instant and related cases, and demand for 90-day stay until MGL, anti-SLAPP civil rights protection under rule remote evidentiary hearing for fraud and lawfare weaponization, criminal contempt probe, judicial receivership, disqualification of Judge Krupp, Ricchetti, Kazjanian, Horstein Salinger, and DOJ referral under Mass Rule Civil Procedure 59E and 60B, MGL C211, 3 with incorporated memorandum of law, and then exhibits. So this is kind of like what we do. Oh, that's not something we're going to share on screen for sure. For sure. Jeez Louise. My Atlanta. Sometimes also these things go down rabbit holes that I don't want to necessarily go down, right? There's got to be like a euphemism for that, like a poisoned rabbit hole, like one that, no, thank you.
White rabbit hole.
It's a white rabbit hole. That's what it's called.
No, I just came up with it.
Oh,
because it's funny and it's smart.
We can ask chat.
How about we don't?
I'm gonna, because I need to know now. Is there a euphemism for like a rabbit hole that's like poisoned that you really don't want to go down? Like it's bad. It says, yes, if you want the idea of a rabbit hole, you should never go down. There are a number of expressions, each with a slightly different feel. A toxic rabbit hole, probably the clearest modern phrase. A poisoned rabbit hole, evocative, though less common. A snake pit, that's kind of what I was thinking of. Like, I think about, like, we used to own a snake, snakes, ball pythons. And they didn't ever eat rabbits, but they could out in the wild. They could eat a rabbit, right? Rodents are prey. So I'm thinking of like what would be coming up out of that rabbit hole that a rabbit would be like, dangerous. And a snake would be one. So a snake pit, a dangerous place full of deceit or conflict. But that's not really has to do with a rabbit. A hornet's nest, something that will stir up major trouble. A tar pit or quicksand. You're not getting, I think the first ones were probably right. A toxic rabbit hole, a poison rabbit hole, yes. If you're looking for something more colorful for commentary or YouTube, see, it knows. It knows that I'm talking to you guys. No, it doesn't. That's not a rabbit hole. It's a toxic sinkhole. That's a radioactive rabbit hole. I like that, radioactive rabbit hole. A rabid rabbit hole. A contaminated rabbit hole. A cursed rabbit hole. I like radioactive or rabid. Yeah. So we're not going to look at that. So we know there's a case. And it's got that judge's name on it and other people, and we're going to leave that. You guys have the case number. If you want to take a look at it, feel free. I'm all set with that. There was one case, though, that I really want to. Oh, it's this case. Hang on. Not that. Not that. Not that. Not that. Maybe this. No. Let's see. My goodness. Oh, you know what I can do? That's one thing people will hear me say. I bet you I've said it to you guys a bunch. You know what I can do? I can look for it somewhere else. Let's see. I know I sent it to Bob Mata. Let's see. There we go. There we go. There we go. Okay, so I want to pull that one up. Let's have a looky-loo at this. So this is robot law. Robot lawyer. AI lawyer. So we see... Actually, I want to pull the other one up first. So we see this filing, okay, in the case, and we're like, what is this about? So, non-party witness, Lieutenant Brian Tully's motion for leave, to file a corrected memorandum. Non-party witness Lieutenant Brian Tully, retired through counsel, respectfully moves for leave to file a corrected citation in his memorandum in support of his motion to quash, subpoena, and or for protective order. After filing the memorandum, after filing it, counsel discovered that one citation on page 6, section 1A, inadvertently cited an incorrect Massachusetts case. Counsel respectfully requests leave to substitute the corrected authority. Cronin v. Strayer, 392, Mass. 525, 534 through 35, 1984. That was a case, remember? Wasn't that a case that the judge cited as well? Remember? Because I remember him saying Cronin in 1984. The correction does not alter the argument presented, the legal proposition for which the citation was offered, or the relief requested. It is submitted solely to correct the citation and assist the court. I wonder, would like the clerk have reviewed this motion and said, like the clerk at the courthouse, right, the judge's clerk, have reviewed Tully's motion to quash and said, gave him a little ringy dingy and said, hey, by the way, these cases that you cited, they don't exist. They don't exist. Because the original motion, 1, 2, 3, 4, 5, and 6. And, oh, you guys can see it. So, a third-party subpoena cannot be used to circumvent federal discovery limitations. Courts have consistently recognized that their inherent authority to stay or quash subpoenas, where the practical effect is to circumvent the discovery framework or a parallel proceeding. See McGuire v. Cunningham, 56 Mass. Appellate Court 160, 164, 2002. Is that a accurate case citation? Are the other two? So, my question is, how would they have known? It would have been, am I right to say that it would have been the court clerk, the judge's clerk, who would have read the motion and said, hey, this isn't a real case, right? So now this is what happens. And this is one reason that the courts are having a hard time with AI and Chat GPT and all that, because Chat is notorious for making cases up. It's like hallucinations. Make cases up completely that don't exist. And we've talked about it on this channel before, that the very first class that I ever took in legal studies was cyber law. And the very first lesson we learned was about a New York case. And it had something to do with like airlines or something like that. And it was two attorneys. One of the attorneys was pro-hocked in, and that person was the one who used Chat, and the case, the cited case was made up. It was a hallucination. So the court called him out on it, and he doubled down and was like, no, it's, and at one point I think he like blamed it on his paralegal, which that's a bad look. For me, I mean, I think maybe that's something that lawyers do, pin it on the paralegal, which is shitty, but yeah. Oh, Melanie Little said it was the first case that did not exist. It's out, like, It's really not that hard. Like, even if you want to use an assistive, like, an assistant AI to help you with drafting, to help you with research and all that stuff, really, lawyers get paid the big bucks. Go back and second guess it. Yeah, his pro hoc status was taken away. Let me see if I can find the case. Because it was definitely, what's the New York case where the attorney was pro hoc and used AI, and it was a case hallucination. As soon as I see it, I'll know what it is. Yeah, it was became a landmark AI hallucination case. Yep. It's all coming back. It's all coming back to me now. So Steven Schwartz was the attorney who used ChatGPT to research the brief. Peter DeLuca was the attorney of record who signed the filed brief. Their law firm was Levido, and Oberman. So Steven Schwartz was not admitted in the Southern District of New York for that case and did not file a notice of appearance, yet he performed the substantive legal research and drafted the filings. Judge P. Kevin Castell held that Schwartz could still be sanctioned under Rule 11, even though he was not the attorney of record. Peter LaDuca, who was admitted and signed the filings, was also sanctioned. So what happened? Schwartz asked ChatGPT to find some cases supporting his client's position. ChatGPT fabricated multiple cases, including Varghese v. China Southern Airlines. That was the big one, was like, cases don't exist, bro. Shaboon v. Egypt Air, Martinez v. Delta Airlines, Miller v. United States, Peterson v. Iran Air, Estates of Durden v. KLM Royal Dutch Airlines. These cases did not exist, but the attorneys submitted them to federal court with fabricated quotations and citations. Even after opposing counsel and the judge questioned the citations, the attorneys initially continued to rely on them and submitted purported copies generated by ChatGPT. The judge, was not pleased. So the judge emphasized that there's nothing inherently improper about using AI for your legal research, but the attorneys failed to verify the cases, submitted non-existent authorities, continued to rely on them after they were challenged, and made false or misleading representations to the court. The court ordered a $5,000 monetary sanction against the attorneys and the law firm, letters of apology to the judges whose names had been falsely attributed to fabricated opinions, and other remedial measures designed to deter similar conduct. So that was, like I said, the very first case I learned about in cyber law. And it was like, I think that was the first class I had to take too. So it was like from jump, from the beginning, they want you to know. Don't do it. Don't do that. So I have it pulled up here. The case in Gildea, U.S. law. And yeah. Very interesting. I will throw that case. Hang on. Let me see if I do this. I want to throw it into the chat. Okay. No, I don't. I'm going to put it in the description. Sorry. So that if you guys want to look at it, you can do that. So I think that is it for today. What do you think, little law girl? Do we have anything else?
I don't think so.
No.
I also don't see Bus Stop Live set up.
Yeah, jump out of it and then jump back in just to take a look.
Something like no.
So if the judge permanently banned Proctor's depot, they wouldn't be able to use it in the federal case. I don't know. That's a good lawyer question. I would not think so. I wouldn't think that's the case because it's two separate cases. And I think that's one of the whole ideas, right? Is that they're two separate cases or many different cases. So they're not supposed to affect each other that way, but obviously they do affect each other. And the federal case, it shouldn't affect that, I wouldn't think, because it's a totally different court, a totally different judge, a totally different lawsuit, right? Is my guess, but it's just a guess. Right, I want to put it in the description so that if you guys want to go back and take a look at the case, if you follow this Justia link, it'll bring you to it and you can read the whole case, which is very helpful. Alrighty. Okay. All right. The judge was trying to do that, but a lot of lawyers said, no, they can't. Yeah. Just weeks ago, a Morgan & Morgan partner was denied pro hoc vice entry. I saw that into a Mass Superior Court case, Harvard morgue scandal, due to a prior sanction in, is that Wyoming, for filing AI hallucinated case citations. It can have lasting effect. For sure. You know, you don't want to be caught doing that. And how hard is it? Like, realistically, if I were to use an AI assistant to draft a motion, a pleading, a whatever, I would absolutely, it takes no time at all to copy and paste it and throw it into a browser. And pretty quickly you'll be able to discern, rather, whether it's a case or not. Just moving too quickly. But is it worth your name? Like, I think of it that way. You go through law school, you go through your undergrad stuff, then you go to law school, and then you get your JD, and it's like, you would risk that. Not that you would lose it, but, you would risk your name. Yeah, pro tip, don't get your Cliff Notes in case law from AI, yeah. Sorry if you covered the timestamp. I was late and going to rewatch. The UK is BST ATM, not UTC. So the UK is 5 hours in front, not 4. It's, I don't know. We did go over it in the beginning, and Corey Hopkins she posted a explanation that shows what it is. So, and I put that, we have that at the beginning. So you can take a look at that, and it will, all that like UK, UTC, BST, that is all the 5 hours of like, it is complex. I don't want to say complex, but it is. So I'm not going to try to re-explain it when Corey Hopkins did a really good job with what she posted and explained it. So it is earlier in the video. So you'll catch it when you go back and watch the rewatch. Lori says, but I can see that's why AJ was probably more upset yesterday. Yeah, watching Grant's video there of him coming out, like he's not gonna. Some had thought too, like, is the judge leading up to putting a gag
Or
on
cameras out of the courtroom.
Yeah, others had said taking cameras out of the courtroom, like little law girl just said. I don't know. But I think at the end of that video that we watched, that thank you to the trial channel, I forgot to put them in the thing too, in the description. I need to do that. And I will also put Larry Foreman's YouTube in there. It is best practice. It is best practice when you are a content creator. Well, when you're whatever that term, content creator. I don't want to play it. There we go. But to share, always share the channel, the video, so that the creator gets credit for it if you guys go and like it. So I have put in there the trial channel's YouTube, the link to that video that we watched, and I also put Larry Foreman in there. So it's all in the description. Everybody plays pretty fairly that I have seen on YouTube, and everybody tries to be really like kind and considerate. Did I not put, hang on. I want to make sure I put Ian's in there too. He is always such an awesome, gracious guest and very informative. So, and he is very cognizant as well of giving credit and other creators and all that. And he also he has like a segment called Robot Law, which is hysterical. I hope he goes over that Buchanan one. The O'Keefes can lose also, correct? Or if the judge sanctions the lawyer, will the O'Keefes be affected? I'm not sure. I'm not sure. I don't think that, but I'm not sure. So I would refer you back to the lawyers on that. So Melanie Little, I'm sure has explained it, or Defense Diaries, or Ian's explanation of it is pretty short. I think the video itself is like 50 minutes. It's, yeah, one of his shorter ones, 59 minutes. So I would be willing to bet all your questions are answered in there. Also, I wonder if you can use, hang on. Okay, so let's put Tammy's question into, let's bring this up. Okay, so this is Ian's video. Okay, so Karen Reed hearing, judge choose out counsel, no opportunity to respond. So I went to this little ask right here. Okay, and then it's going to pop up a window over here, and I'm going to ask Tammy's question. Hang on, we'll just put it in just like you asked. If the judge sanctions the lawyers, well, you could write it correctly. The lawyers, will the O'Keefes be affected? and we'll see if Ian answered it. The video states that if an agreement regarding the confidentiality of information is not reached, the judge has threatened to enter an order that could include sanctions such as dismissal or default. The speaker implies that such actions, particularly a dismissal, would impact the legal proceedings and the parties involved. So you may need to ask that question differently or on a different channel, because it's possible that maybe Ian didn't answer that in a way that, and this is also AI, right? So you're just going through, basically it's going through the transcript to see if it answers your question. These are some great questions it comes up with though afterwards that maybe you didn't even think about asking. And AI is like, well, isn't this, maybe this is interesting to you? I don't know. And it says AI can make mistakes, so double check it, right? So the first one it comes up with is, why did the judge single out Jackson? And it's going to answer it. It takes a second, so don't think that like if you see it sitting there and not doing anything, so according to the speaker, the judge, see, I disagree with this. AI is worth nothing. I disagree wholeheartedly. It is useful. You just have to be careful using it. And clearly, based on where we begin this segment with regards to Tully and his robot lawyer, it needs to be checked. So it's not useless for sure, or worthless. So according to the speaker, the judge singled out Attorney Jackson for specific scrutiny, such as requiring his in-person attendance while allowing others to appear remotely, and calling out his name for free publicity because the judge appears to suspect Jackson of being involved in the leaks, even though the judge has not presented specific evidence to support this. So now keep in mind as well that this is not giving me an answer based on the proceedings. Like, it's not telling me why Alan Jackson was singled out. It's telling me what Ian Runkle believes, why he believes that, right? So it's analyzing what Ian Runkle said, not what actually happened in court. People absolutely do use it wrong. Yeah, absolutely. Yeah, it's a robot and it's trained on data sets. It's trained on, it's a large language model, so it's trained on our language, right? And the data that AI is trained on is mediocre at best. I would disagree with mediocre at best, but it is useful in some regard, but it's certainly not perfect or anywhere near perfect. Ian does a great job of explaining, like, it's like your assistant who once in a while wants to see you unalived or something tragic happen. Yeah. So with that, we will check in on our grift again quickly, and then we will send you off. Nothing, little law girl. Can you refresh that? Alrighty. Nothing? All right. Well, you guys are free to roam. Free to roam. You're always free to roam, but enjoy. You're out of my class. I wonder, is that loud for you guys? I wonder if I can adjust the volume on it. I think today we'll be spending with you guys roaming around the YouTube streets, and you have a good day as well. Yes, if they sanction, then they will need the proof for where the leak came from. Yeah. In Lawyer You Know chat, someone said that Lisa lies a little, and the other person from the law firm had a company sign in the Zoom background. Yes, they did. You can see it. Stay away from my channels. What channels are those? What are you going to be watching today, Zach?
Shut up, Zach.
Don't tell Zach to shut up.
I just did.
Well, if he wants to pick on us, he's got plenty of great content today, that's for sure. This is the face I give Zach. That Karen Reed stare. I love it. Yeah. You know what? You're all big and bad here, but we know. We know. All right, friends. Well, have a great day, and we'll see you when we're looking at you. Bye.
What can I say? You can't fix stupid, but you sure can punch it in the face. That's what I would say to you, sir. You're unbelievable.